Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome all of y'all back to Smart Low TV. Before I begin with the topic of this video, y'all already know the routine. If you haven't already, please, I really appreciate it. Go ahead and hit that like button and subscribe to my channel. Um, I'll give y'all a second to do that. All right, let's get to it. Um, this is what I want to talk about today. Let me show y'all this case right here. This is a lot of people talk about this case right here. A lot of people. And that's what I'm going to talk about. First, I want y'all to know that this is a real case, and it like this citation. I'm sorry, this citation to a certain degree it is in here. So let's go down, and I'm gonna show it to you right here, and I'll explain it to you. Why the court did what it did. The defendant's motion to dismiss for failure to state a claim unsupported by affidavits or depositions is incomplete because it requests the court to consider facts outside the record which have not been presented in the form required by Rule 12b-6 and 56C. 56C of the Federal Rules of Civil Procedure, that is a motion for summary judgment. And a Rule 12b-6 is a motion to dismiss of the Federal Rules of Civil Procedure. So statements of counsel in their briefs or arguments, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss or summary judgment. The reason is because there are no facts. The attorney cannot testify because he's not a witness. No attorney can, let me rephrase that. Nobody can testify if they are not a witness. Only witnesses who have personal knowledge can testify. And they have to be competent to testify. That's in the federal rules of evidence, just to let y'all know. And it's also in your state, the state rules of evidence, just to let y'all know. Now, another thing I want to tell y'all is that's a principle, just to let y'all know. That does not just apply, like right here, statements of counsel in their briefs. That's a principle. That does not just apply in Pennsylvania. And I posted that on my YouTube channel just to show y'all. I did that in the community section on my YouTube channel to show y'all. And I'm going to pull that up for y'all right now. And I'm going to read all of them to you. Every last one of them. This is a principle that applies in every state. Plaintiff's counsel does not have personal knowledge of the events alleged in the amended complaint. See this? There it is right there, Federal Rules of Evidence 602. Personal knowledge. You cannot testify if you're not a witness with personal knowledge and who is competent to testify. If you are not there, if you don't have all of those elements, then you cannot testify. All testimony must be based on a witness's observation of the matter about which he is testifying. See this? In addition, counsel's characterization of witnesses' testimony is not personal knowledge and is likely based on hearsay. These are the cases right here if y'all want to read this stuff. I'm going to keep reading it, though. I'm not going to cite y'all the cases. Y'all can go find these cases and read them if you want to. Let me rephrase that. Go read these cases because y'all need to know this stuff. The affidavit must be based on personal knowledge and not on hearsay statement of another purported witness. An affidavit or declaration used to support or oppose a motion must be made on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify on the matter stated. Do y'all see this? This applies to police officers too. When they swear these police officers in and they go to telling you that you're driving and these motherfuckers don't know what driving is, so they're not competent to testify. See what I'm saying? Or they tell you, you was being disorderly. They just say you were acting disorderly, which is a conclusion of law because they're not giving facts in support of that conclusion when they're testifying. So on and so forth. This applies to everybody. Accordingly, the court would not consider counsel's affidavits in ruling on the pending motions. Let's go on down some more. The reason why I pulled up different cases that say this in different so-called states is to show y'all that this is a principle and it applies everywhere. Statements of counsel are not evidence. This is California. Statements of counsel are not evidence. This looks like Kansas. This is Minnesota right here. Statements of counsel are not evidence. Minnesota. Statements of counsel are not evidence. Tennessee. You see this? This shit applies everywhere. This is a principle of law. That's a principle. Accordingly, affirmations from attorneys having no personal knowledge of the facts are not evidence and offer nothing more than hearsay. I want y'all to get this now. Make sure y'all are getting this stuff. The purpose of me of doing this video is to show y'all that this is a principle and it applies everywhere. Nobody can testify unless they have personal knowledge and they are competent to testify. They have to be, one, they have to have personal knowledge, and two, they have to be competent to testify. Those are the ingredients. Attorney statements not based on personal knowledge lack evidentiary value. What is this? This is Minnesota. Here's another one. It is always improper for a prosecutor to suggest that a defendant is guilty, and they always do that, merely because he is being prosecuted or has been indicted. The personal opinion of counsel has no place at trial. Expressions of personal belief of the innocence or guilt of an accused are error. We agree that the prosecutor's comments were improper. See this? This is a principle of law. Nobody can testify if they don't have personal knowledge and they are competent to testify. That's it. So I hope this makes sense for y'all. If it doesn't, go read these cases because they'll explain it to you better. Go read these cases. The reason, like, I post this stuff on the community section of my channel on YouTube for y'all to go and read for yourself. That's the whole purpose of me doing this. Let me go back right here. Here it is right there. I'm expound on this one a little bit because anytime that they're motioning to dismiss or a motion for summary judgment, they have to be supported by evidence. And they have to be supported by affidavits, as far as like an affidavit, a deposition, request for admissions, request for productions, interrogatories and stuff like that. All of those are instruments that are used in discovery. Those are discovery tools. The affidavit must be based on personal knowledge and not hearsay statement of a purported witness. And there's the case they're citing at Second Circuit. See also Federal Rule Civil Procedure 56C4. An affidavit or declaration used to support or oppose a motion must be based on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify on those matters, on the matter stated or whatever. Do y'all see this? Nobody can testify if they do not have personal knowledge and they are competent to testify. Nobody. Because the testimony is the evidence. Okay, the testimony will have the elements of the prerequisite. Let me rephrase that. The testimony will have the prerequisite elements that whoever is getting this man or woman to testify that they're seeking. It's going to have those elements that they're seeking, that they need in order for the court to take that testimony and apply. Let me rephrase that. To take the facts of that testimony and apply the relevant case law to that set of facts and to determine if these facts are sufficient or insufficient in law. That's the only purpose of that. That's it. Ain't nothing else. That's it. The fact, I keep telling y'all, everything is about the facts. I don't care if you're petitioning for a motion for summary judgment. If you're filing a motion for summary judgment, you better have facts in there. You got to have it in there. If you're filing a petition for a writ of habeas corpus, you need the facts to support why that writ should be granted. If you're filing a petition for a writ of prohibition, you need the facts in there to support why that writ should be granted. Doesn't matter what it is always about the facts, because the facts are the elements that the judge needs to determine if they have grounds to grant you your remedy, or so to speak, if that makes sense to y'all. It's always about the facts. Always. So if a police officer, they file a complaint against you and they say you unlawfully operated a motor, that's a conclusion. How the hell do you have no facts in here to support how I am, how you are unlawfully operating a motor vehicle, or so on and so forth. All of these are conclusions, because a motor vehicle, that's a legal term. A other vehicle, that's another legal term. All of these words have been construed. These people are playing word games. File a motion to dismiss. This shit is vague, it's conclusory, and it's devoid of the prerequisite elements of the offense. And it's legally insufficient as a matter of law. This ain't no damn complaint. It just looked like one. Matter of fact, it don't even look like one, because it's not one. Like me, these are the type of the arguments that I make in court. That's why I don't really go to court unless I want to. But let me stay on topic. Anyway, I just want y'all to understand that this is a principle. Okay? It's a principle, y'all. Nobody can testify if they don't have personal knowledge and they are competent to testify. Nobody can. Nobody can. Anyway, I hope that helps y'all understand more about that particular principle. If you haven't, again, please subscribe to my channel. Give me a thumbs up. I really appreciate it. The Supreme Litigant is out. Peace.